This is a review of the various court cases that we're going to talk about throughout the quarter, but I've put in a short PowerPoint for you to quickly review and cover. The first court case is Terry v. Ohio. This case has to do with the Fourth Amendment. A quick review of the case. An officer was working at night. He was in plain clothes and he observed some men that were standing across the street from a convenience store, and they were kind of just talking to each other, and they would talk and then they would walk inside the convenience store, and they did not see the plainclothes policemen, and they would go inside the convenience store and they wouldn't buy anything, and then they went back outside and they would continue talking, and then a third man came up and talked, and they were all three talking, and then they'd go inside the convenience store and they would watch the clerk ring up some things, and then they would go back outside, and the plainclothes policeman was thinking, something's going on. I mean, what do you think those three men were doing? What would you be thinking was going to happen if they weren't buying anything? If it was, like 2 or 3 o'clock in the morning, and they were watching the clerk ring up other people, and they were really kind of casing the convenience store. If you're kind of thinking maybe they were planning on robbing the clerk, maybe you're right. So at that point, all that we had was what was called probable cause. And what that meant was, if a reasonable person thinks that somebody has committed a crime, an officer could stop a person. Per the Fourth Amendment, an officer could detain that person, could fully search that person, and could arrest that person. But that's what officers had. So that officer went up to those three men, and the officer did what was called a pat down. We didn't have a pat down at that time, or anything that we called a pat down, but he did a pat down. He kind of did a pat down, or frisked the men, and he found weapons, found guns on two of them. And Terry, he didn't go inside their pockets, but he felt from the outside, he was like, that's a gun, because he could immediately tell, hey, you're carrying a gun. I can tell just from patting down the outside of your pants that you're carrying a gun. And so Terry wasn't supposed to have a gun, and he was sentenced to prison. And so Terry had an attorney, and his attorney said, hey, you know what? This officer did not have probable cause to stop Terry. He shouldn't have stopped him, because to have probable cause, you've got to have a lot more information, and there could have been lots of reasons that Terry was standing out there, and maybe he wasn't going to rob. How did he know he was going to rob that store? And so what ended up happening was this went all the way up to the Supreme Court, and what you see at the bottom is the conclusion, and that's the Supreme Court. It was an 8-1 decision, and the Supreme Court came back and they said, you know what? We want our officers not to just be reactive, because right now that's what they're kind of doing, is they're being reactive. We're not giving them the tools to go out and stop things like robberies from happening. So we're going to give them what's called reasonable suspicion. So if an officer has reasonable suspicion, such as they see something like what Terry was doing that night with his two friends, and they think that a crime is going to happen, they don't have to have probable cause to believe that a crime has already occurred. They can actually stop, they can detain a person, and depending what state you're in, for example, in Oregon, officers can detain a person for a reasonable amount of time. You may see that somewhere else on a quiz. In Nevada, for example, you can detain a person for 60 minutes. So you can detain a person with reasonable suspicion for either a reasonable amount of time or a certain amount of time, depending on your state, like Nevada, for 60 minutes, just like I said. And you can pat them down for weapons or evidence of the crime that you think that they may be committing. That's why you stop them, is to investigate further. Now, reasonable suspicion doesn't give you probable cause to arrest somebody. It just gives you the right to further investigate. That's what the Supreme Court did with, oops, I went further. Sorry, I didn't even notice that I had hit my arrow button. So we're still on Terry v. Ohio. So it just gives officers the right to investigate further. So the difference, again, just to let you know quickly, is that Terry v. Ohio gave officers reasonable suspicion. It gives officers the right to stop, to detain a person. The length of time that they detain somebody depends what state they're in. If they're in Oregon, it's a reasonable amount of time. It gives the officer the right to pat down somebody, not go in their pockets, but wherever they have, their hands, they can go into their pockets, such as, like a sweatshirt has those front hand pockets, they could go into that, or pants pockets, they could go into that. They can pat down if they immediately can recognize, hey, that's a knife or that's a gun, they could go in and get it. And it's different than probable cause, because probable cause is what you need to get a warrant. Probable cause is what you need for an arrest. And with probable cause, officers can arrest somebody and they can fully search as an incident to arrest somebody. Okay, so that's a quick overview of Terry v. Ohio, and it's really important. Next, Tennessee versus Garner. So during the chase, and this has to do with the Fourth Amendment as well, 15-year-old Elton during a chase, police officer Elton Hyman shot 15-year-old Garner. Garner was a suspect. He had burglarized a nearby house. And what had happened was the officer had got there. Garner was running away. The officer said, stop. And he was fleeing. Garner didn't stop. And the officer shot, and he died at the hospital. And so this was taken all the way up to the U.S. Supreme Court, and the U.S. Supreme Court said, hey, unless officers are trying to stop the escape of a dangerous fleeing felon that's hurting somebody and they're causing harm, officers are not allowed, that it's unconstitutional to use deadly force to prevent the escape of an unarmed fleeing felon. So Tennessee v. Garner is huge. So you have to understand that. So after the Garner, before that, officers could do that and stop a fleeing felon. So I always have students say, well, when can officers shoot somebody in the back? Well, the perfect example that I always use is an active shooter situation. If you have somebody in a school that is shooting people in a school, and even if they have their back turned to the officer, but they are causing harm and shooting people or killing people, then that is a reason Tennessee v. Garner would not apply, because they're actively harming people and the officer has the right to stop them. All right, Miranda v. Arizona. This has to do with the Fifth Amendment. So this is one of the most misunderstood cases. I always get asked a lot of times, and this is the most common time I get asked it, is when I would pull somebody over, I would see them with my own eyes. And this is the most common. The light would be green, the light would go yellow, and then the light would go red, and then somebody would go zoom. So let me do that again. The light would be green, yellow, red, and then their car would go zoom. So it was pretty obviously they ran the red light. No confusion about yellow, red. It had turned red, and then they went zoom. Okay, I've told it 3 times, so I think it's pretty clear. I saw it with my own eyes. So I would have people say, I would write them a ticket, and then I'd say, okay, you have to show up here. You're not saying you're guilty by signing this ticket. You're just saying you're going to show up at court to plead guilty or not guilty. And they would say, you have to read me Miranda. And I would always say, you're not understanding Miranda. So what had basically happened was it's Miranda v. Arizona, that Miranda was arrested in connection with a kidnapping and rape. And after 2 hours of interrogation, police got a written confession from him, and the police officers admitted they had not advised him of his right to his attorney. And on appeal, the Supreme Court said that his constitutional rights were not violated because he did not specifically request cancel. So what ended up happening, in the long story short on this, is what it basically says is it's kind of what we call like a two-prong test. Is if you are in custody of the police and you are not free to leave, that's the first prong, and you are being interrogated, okay, not questioned, but interrogated. There's a difference between being questioned and the police are just wondering if something happened and they're just filling things out, or if you're being interrogated, meaning that they think you committed this crime and they're trying to get you to pretty much confess. Then they have to read you Miranda. So make sure you're not watching too much fictional TV, which means it's make-believe and not real, and that you understand what Miranda is before you engage your Miranda rights. All right, Brady v. Maryland. So to give you the short view of this, we call this Brady. We don't use Maryland a lot of times. In fact, a lot of cops don't even know the second part of it. We just call this the Brady rule. And what it basically means for cops is it's called the lie rule. And it means that for cops, and you'll hear a lot of it these days, is if an officer is ever accused of lying, generally a police department will put them on administrative leave, because whenever they have to testify in a court of law, the defense has to be told that they've been accused of lying. And that's not good if you think about it, because imagine if that officer had to testify in a court of law that they saw a murder take place. And let's say that in maybe 15 years ago, they lied on a report. And let's say it was just something small, like they put a car on a report was black with yellow pinstriping, and the car really was black with yellow pinstriping. Well, let's say that they lied on the report because they were really tired at the end of the day and they didn't want to call the witness to verify the color because they couldn't read their handwriting. And that the sergeant just told them, don't do it again. Well, that's not really good, because can you imagine if the defense found out and now it's 15 years later and they're testifying that they saw the murder and they know who murdered the victim, and the defense attorney says, have you ever lied? How can we believe you? And they say, no, you can believe me. I'm a police officer. I always tell the truth. And then they bring up this lie about the color of the car and the pinstriping. Is that going to cause reasonable doubt for a jury member? You bet it is. So this Brady case is really important. And so honesty, integrity, and never lying is really important for police. All right, this Graham v. Connor case. Basically, this is another Fourth Amendment case leading into, sorry, not Fourth Amendment. This has to do with what we call really, really, really important stuff. It's a long case that goes into excessive force. And so I'm going to take the time to make sure you really understand this. So back in the 80s, Graham was a diabetic and he had an insulin reaction while going to work. He asked his friend to drive him home, or drive him to a convenience store to purchase some orange juice. When they got to the store, he saw a lot of people at the store. He didn't want to wait in line because he's having this reaction. And an officer saw this and saw him go in and out. So he pulled over the car with Graham in it. And Graham, who's suffering from an insulin reaction, exited the car and ran around it twice. And he passed out. Graham passed out because he's having this insulin reaction. And when he woke up, he's handcuffed, laying face down on the sidewalk. And basically the officers have now picked him up and put him over the police, the front hood of the police car. He's trying to show him, Graham's trying to show him, hey, I'm a diabetic. This is what's going on with me. There's some resistance that occurs. And the police officer's trying to figure out if there's been any crime that's occurred at the convenience store. And so Graham files charges against the officers for what happened by violating his rights and using the excessive force by what happened. And so anyhow, what ends up happening is the questions that are asked of the court is that Graham has to show that the police acted maliciously and statistically for the purpose of causing harm, and Graham's claim that the law enforcement officials used excessive force must be examined under the Fourth Amendment's objective reasonableness standard. And so the conclusion of the U.S. Supreme Court in a unanimous ruling written by the justice of the court held that the claims of excessive force used by the government officials are properly analyzed under the Fourth Amendment's objective reasonableness standard. The court vacated the directed verdict and remanded the case to the district court to be decided. They noted that 1983 in itself, in which we're going to get to what 1983 is not a source of substantive rights, but rather a means for vindicating federal rights. And the Fourth Amendment stands as one of the two primary sources of protection against physically abusive government conduct. Therefore, the validity of Graham's claim must be judged by a reference to specific rights. So basically it said that we have to look at the objective reasonableness of the use of force, and that the use of force must be judged by the perspective of the officer on the scene and the severity of the crime, which leads us to finally what we're going to end with, which is 18 U.S. Code 242, deprivation of rights under the color of law. So officers cannot, because of their position as a police officer, use their position to take away anybody's rights under the color of law. So the best case I can utilize where we look at Graham v. Connor is the case of Rodney King. So Rodney King, the officers were first charged with excessive use of force. When they were found not guilty, the officers were then charged with 18 U.S. Code 242. The difference is Graham v. Connor was a municipal code or a state code that they utilized excessive force, and then the 18 U.S. Code 242 is a federal code. So when you start talking about different codes, and when you learned in CCJ 230, American Criminal Justice, you learn that there is municipal city codes that are misdemeanors, and there are state codes, which are felonies. Excessive use of force is a felony. It's a state code. So those officers were charged with felonies, and then officers, if they take away somebody's rights under the color of law by using excessive force, this is a federal code, and this is a felony that you go to federal prison for breaking. So very, very serious things. All right, that will end our quick review of some really important court cases that you need to know and understand. Again, we cover these more at various times throughout the quarter. This is just a quick review of all of them in one place.